Let's get you more news worth your attention this Tuesday. The Standing Committee on Public Accounts, that's SCOPA, is doing crucial work. They are set to hear from officials from the Road Accident Fund, but it seems before that they're engaging officials from the Transport Department as they look into claims of misused public funds and poor management. Speaking currently is Mkhuleko Hlengwa, who's ironically the former chairperson of SCOPA, but is there in his capacity as the Deputy Minister of the Transport Department. Let's listen in.
To insure my leg if my leg is expensive, and not to turn to REF as a means of bridging that. So the socio-economic challenges that colleagues raise for me are fundamental because they are what bring us to this backlog. They are the issue of access there, and then the issue of liabilities that colleagues correctly point out to, and amongst others, Chair, the Concord action which REF is involved in, and the Auditor General, the directive that remains the position of the ministry since arrival and now is that the AG must pull out, the REF must pull out of that action with the AG in court. And we find a responsible way within the accounting standards to deal with the liabilities question. Lastly, Chair, you make an example which I think must not be taken lightly about how somebody approached you to assist you, and you made about somebody being hurt in Mgidin. That is part of the corruption within the REF ecosystem. I've made the example here how my brother was accosted and being hijacked and beaten up by people, and we rushed him to hospital, and I came outside to somebody said, you should have said it was a car accident. That is part of the corruption embedded within the REF ecosystem. And so we must not lose sight of the fact that people see REF as a money-making scheme. And so the stringent claim processes are amongst others, but maybe we can say REF, done a claims process overreach and went above and beyond strengthening its processes. But in part, it's a response to the corruption embedded within how people kick off a claim process. Thank you, Chair.
All right. Thank you very much. Can we just get those answers dealt with in 10, and then we'll go on break?
Chair, thanks. I think I would want to speak to Honorable Mente. I think one of the questions you asked is why would somebody make an offer and then thereafter probably want to deal with it? Potentially because I've not seen the case, and I would want you to give me the case and we'll then give you a written response. We'll investigate what's going on there and provide you a written response. But potentially sometimes people might make offers that they're not supposed to make, and if they are found fundamentally to be problematic in law, then they might have to be dealt with in a court of law. But I am not sure of the specifics of what you have there. Can you indulge us to have a look at it, and then we will put in writing exactly what could have transpired there, because I don't want to make assertions, and I'm not sure what could have been the fundamental fight the RAF is having with that particular claim. But we will Chair, look at it and respond in writing to the committee and explain what could have transpired in that particular claim. I think I wanted to deal with that. Maybe Mr. Mkhawela, I think there were a few questions around the call center and why did we reach to everybody else and so on. I think Mr. Mkhawela will tackle those.
Through you, thank you, Chair. Firstly, to Mr. Isaac, nothing is hunky-dory at RAF. I think that is a fact. But number two, the establishment of the contact center was an admission that we're dealing with decades-old problems. We have claims which are even more than 10 years old. Now, with us calling all the claimants, it was an attempt to say we're sitting with these claims, which are an indication of our liability. We have to do something about that. That is why we're not discriminatory on who we're calling. But these are some of the dispositions that we picked up. We are not able to reach at least 38% of the claimants, Chair, I must say that. Part of the reason is that they've changed numbers. The service providers, if you don't use the number for more than 6 months, is given to someone else. it's been a struggle for us to reach those claimants. But we did not stop there. We are making use of tracing agents to say, how can we reach you? Because the last number that we had was this number. Up until we have spoken to you, we will not be able to assist you because we don't know if you are even still alive for that matter. So the contact center, yes, was established. It's just under 2 years. We have had more than 1 million interactions through that platform. But we are now in a better position to understand who's calling us and why are they calling us. In the past, Chair, we had a very small contact center manned by very few warm bodies. We could not even tell if we're dealing with repeat calls, let alone the total number of queries we're dealing with. Where we are right now, we know exactly who we're dealing with, direct vis-a-vis the plaintiff attorneys. We also understand why some of the claims are not moving because of the issue of the outstanding documents. So through the contact center, we'll call and say, Mr. Isaac, we are still awaiting a medical report, which your attorney hasn't finished out yet. It will be impossible for us to progress further than that. But we do have instances where the reports were submitted, but the whole claim had to be investigated because of suspicion of other, corrupt practices that the DM also alluded to. So it's a function of many variables, but to your point, we are reaching more of our claimants than we ever did in the history of the fund. We are also, as I've indicated earlier on, digitally reaching out to our claimants through WhatsApp, through SMS, through SSD. So the mode of communication has improved to the point where we can, comfortably say that we have a better idea of where the backlog is and how to eliminate that. So I wanted just to make that point, but I'll be covering that when I talk to the queries management, because that's why we go into details in terms of what channel are we using and what are we getting out of that, to make sure that we also use that as an opportunity to educate the public about the claims process in its entirety. Thank you, Chair.
Chair, if I can comment on some of the questions that has been raised. For Honourable Member Madlala, he had asked a question about the 60 days to object, the date stamp. How are we using it, or why did we use that date, the stamp of the post office? It is in the standard operating procedure that governs us on which date we need to use in respect of the lodgement date. So that would cover your question. To answer Honourable Beasley with regards to the 60 days and whether it deems the matter valid in law. So what would happen is, if we do not object to the claim within 60 days, the claim will be deemed valid in terms of that substantial compliance has been met and a valid claim has been lodged. It does not determine liability. That is still something that gets determined at our merits, in our merits department. We are a fault-based system, and therefore, firstly, fault needs to be determined before we move on to investigate the quantum of a claim. A question was regarding the post. So, Madam Mente Nkuna, what would happen is that on a weekly basis, we've got a document management department where part of the duties and responsibilities are to collect post at the post office. Over the past few years, there has been a decline in how we receive our mail from the post office, and it is something that has been articulated and ventilated in a number of meetings that we've had with regards to the opening of, collection of correspondence, and then as well as opening of the documents. This occurs in document management services. All regions, they are supposed to have opened all documents that is coming through the post. In terms of boxes, I cannot confirm whether or not it is...
Sorry, can you just explain this thing around the post office?
So
What has been the challenge there?
So what would happen, and I can speak for Eastern Cape, between the various post offices, if someone in Kabeja sends documents, lodgements via registered mail, it does not get there within a reasonable period of time. So we find that sometimes it can take up to a month or two for documentation to actually reach the post office East London. So this does occur. Yes. And then just the last question on prescription. So what would happen is that the date of accident is the most important date because the cause of action arises on date of accident. Within a period of 3 years, that is in which time a claim needs to be lodged at the Road Accident Fund. After the date of lodgement, there is the 60 days in which to object, and an attorney can issue summons anytime after day 120 if a claim has been registered with the Road Accident Fund. If the RAF objects or we repudiate the claim before the 120 days, that attorney has a right to also issue summons. The 5-year period of prescription runs 5 years from date of accident to the date before which the claim prescribes. So that is the prescriptive periods in respect of the claim. Thank you.
Okay, so this is very important, just to be clear. So the prescription clock, therefore, begins on the day of the accident. Okay. I just, please, I mean,
It's 2 sets of prescriptions.
Okay, so just...
That they need to unpack.
Yeah, please just unpack that. The committee members need to really understand, because earlier we spoke about, the thing arriving and being stamped and so on. So please help us untangle that thing.
Okay, thank you, Chair. So firstly, from the date of accident, you have either a period of 2 years if it is a hit-and-run accident, or 3 years if it is an unidentified motor vehicle involved in the accident, where either the driver or the motor vehicle has been identified, in which to lodge that claim. So that is the first prescriptive period. If a claim is not registered or lodged within that time period, they cannot claim, or the victim cannot claim against the Road Accident Fund. If a valid claim has been lodged within the specified time period, which is 2 years or 3 years, they are then able, the claim needs to be processed within a period of up to 5 years.
Okay.
So a claim can be registered 2 months from date of accident if all the necessary documentation has been obtained for a claim to be registered.
Which is, so in other words, it can be anything from basically up to 7 years, basically, or thereabouts, depending on when the accident happened and when the thing. So I could lodge a claim on month 23 of that 2-year period for a hit and run. There is then another, how many years before it? 3 years, right? Okay, no, I get you. So there are 2 prescriptions. There is a deadline for you to submit a claim. Then there is a deadline for when the RAF is expected to pay. If nothing happens in that period, sorry for you, you came too late. That sort of thing. So there are 2. Okay, thank you very much. I get it. But please continue.
All right, Sungezo Zibi there is the SCOPA chairperson, and they are trying to get to the bottom of the issues at the Road Accident Fund, which are really well documented over the years, quite frankly. Issues around backlog in the claims and issues of millions of rand that is ultimately paid by the Road Accident Fund but doesn't reach the intended beneficiaries. Hopefully, this particular fact-finding mission at the very least will get to the bottom of those issues, and ultimately there will be some kind of resolution given what is at stake.